Applicable law in tort and delict. The Rome II regulation. The rules on applicable law. The regulation provides different rules for determining the law applicable in respect of the two categories of non-contractual obligation covered by it, namely those that arise out of a delict or tort and those that arise out of the other legal relationships. In addition to providing general rules for these two categories within the area of obligations arising out of delict and tort, there are special rules for 5 types of situation, namely product liability, competition, environmental damage, intellectual property, and industrial action. 1.1. Party autonomy, Article 14. Unlike the position under Rome I, choice of the law applicable has a more restricted role for delict and tort cases. Parties are not generally in a position to make a choice before the event giving rise to a claim for loss, injury, and damage has occurred, since in normal circumstances they will not have anticipated such an event, and therefore there is no one with whom the party suffering such loss could enter into an agreement beforehand. This means that it is not possible under the regulation to enter into an agreement on a general choice of law made before such an event. Thus, the timing of the choice is restricted to the period after the event has occurred. There is one situation which is covered by the regulation where parties can enter into agreement to choose the law applicable before the event, and that is where all parties involved pursue a commercial activity. Any choice of law shall be subject to the exception that the law chosen will not be applied where there is a close connection with the chosen law of another country provisions of whose law, which cannot be the subject to contracting out, will be applied. The choice must either be explicit or emerge clearly from the circumstances of the case. 1.2. Applicable law and the absence of choice. Article 4. The general rule as regards an obligation arising out of a delictual or tortious situation depends on the application of the law of the country where the damage occurs or is likely to occur, irrespective of the country where the event giving rise to the damage occurred or to another country in which indirect consequences of that event occur. The objective of that rule, which confirms the lex loci delicti commitio as the law applicable, is to guarantee certainty in the law whilst at the same time seeking to strike a reasonable balance between the person who it is claimed is liable and the person sustaining the damage. However, where the person claimed to be liable and the person who has allegedly sustained damage are habitually resident in the same country at the time when the damage occurs, the law of that country shall be applicable. The regulation goes on to provide a general exception clause which aims to bring a degree of flexibility, enabling the court to adapt to an individual case so as to apply the law that reflects the center of gravity of the situation, so that whenever the delict or tort is manifestly more closely connected with another country, the law of that other country shall be applicable. The regulation additionally provides special rules that apply to some areas of law such as product liability, unfair competition, or intellectual property law. Rules for special situations in delict and tort, Articles 5 to 9. There are various special rules covering 5 different situations as follows. Product liability, Article 5. The applicable law needs to be assessed under a cascade of connecting factors. In the first place, that of the country of habitual residence of the person sustaining the damage at the time the damage occurred, if the product concerned was marketed in that country. Failing that, the law of the country where the product was acquired, if it was marketed there, or failing that, the law of the country in which the damage occurred, if the product was marketed there. If the person claimed to be liable could not reasonably foresee the marketing of the product in any of those countries, it shall be the law of the country of habitual residence of that person. If the case is manifestly more closely connected with a different country, the law of that country shall apply. Unfair competition, Article 6. Various rules apply depending on the situation. Broadly, these rules are intended to protect the interests of both consumers as well as businesses against anti-competitive activity. So, where an act of unfair competition occurs, the law applicable is that of the country where competitive interest or the collective interest of consumers are or are likely to be affected. The general rule in Article 4 applies where the interests of a specific competitor are affected. Specific rules in Article 6 deal with anti-competitive practices, focusing on applying the law of the countries in which relevant markets affected thereby are situated. It is not possible to contract out of these rules by choice of law under Article 14. Environmental damage. Article 7. A delictual or tortious obligation arising out of environmental damage or damage sustained by persons or property as a result of such damage is primarily governed by the law chosen by the parties. However, the person who is making the claim has the choice of basing it on the law of the country where the event giving rise to the damage occurred. The possibility of unilateral choice underlined the general commitment of the EU to the promotion of environmental protection. Intellectual property rights, Article 8. Here, a distinction is drawn between EU intellectual property rights and national rights. As regards the latter, the law applicable is that of the country for which protection is sought. For EU rights, where the matter is not regulated in the relevant EU instrument, the law applicable is that of the country where the act of infringement of the right occurred. Again, no choice of law is permitted for these cases. Industrial action, Article 9. This, the last of the special situations, concerns non-contractual obligations in respect of the liability of a person in the capacity of a worker or an employer or the organizations representing their professional interests, such as trades unions or associations of employers, for damages caused by industrial action, whether already carried out or pending. Whilst in such cases, the general rule in Article 4.2 applying the law of the country of the common habitual residence applies, Article 9 provides that the law of the country where the action is to be or has been taken will apply. Applicable law in cases of unjustified enrichment, Articles 10 and 11. With regard to non-contractual obligations in unjustified enrichment arising out of an act other than a tort or delict, such as unjust enrichment and agency without authority, the regulation provides rules to ensure that the obligation be governed by the law of the state most closely connected to its subject, while leaving the courts with sufficient flexibility to adapt the rule to their national systems. In both situations, there is a hierarchy of rules established. Unjustified enrichment, Article 10. The primary rule is that where the obligation arose out of an existing relationship between the parties closely connected with the unjustified enrichment, it is governed by the law which governed that relationship, say contract. If that does not apply, and the parties are habitually resident in the same country at the time that the obligation arose, the law of that country applies. If that cannot determine the law to be applied, it shall be that of the country in which the unjustified enrichment took place. If the situation is more closely connected to another country than those specified in the other provisions, then the law of that country shall apply. Negotiorum gestor, Article 11. Here, the first rule is similar to that in relation to unjustified enrichment, where there is a relationship between the parties closely connected to the obligation, then the law applicable to that relationship shall apply. The second rule is again to apply the joint habitual residence of the parties, and the third is to apply the law of the country where the act giving rise to the obligation was carried out. Finally, there is a most closely connected rule similar to that in Article 10. Applicable law and obligations arising from culpa in contrahendo. Article 12. Culpa in contrahendo refers to the situation where a non-contractual obligation arises out of dealings prior to the conclusion of a contract, regardless of whether the contract was actually concluded or not. This includes breach of a duty not to disclose information, the violation of and the breakdown of contractual negotiations. Again, the rules in Article 12 provide a mini-hierarchy. Thus, the first step is to apply the law which governs the contract or would have applied to it had it been concluded. Failing that, the applicable law is that either of the country where the event giving rise to the damage occurred irrespective of the country or countries in which there are indirect consequences, or that of the country of the parties' common habitual residence, or where the relationship is manifestly more closely related to a country different from one indicated by the other rules, by the law of that country.